More developments in the George Zimmerman case. Attorneys for Zimmerman headed back to court this afternoon. They're hoping to delay as long as possible a hearing that would decide if Zimmerman deserves immunity for the shooting death of Trayvon Martin. Tony Pipitone is at the Seminole County Courthouse. And Tony, we learned today that the judge will summon 500 potential jurors for the trial.
Yeah, and she wants them here by June 10th. She says she is not going to delay these proceedings unless there's some extenuating circumstances. But with that self-defense immunity hearing set for April 22nd, the defense is doing everything it can to get more time. Now, one solution they floated today, wrap that immunity hearing into the trial itself, letting the judge decide at the end of the case whether the defense has proven self-defense. That's just one of many crucial decisions yet to be made as the pre-trial phase of this case heads quickly into the home stretch. Jury selection is still more than 3 months away, but it wasn't too soon today for George Zimmerman's attorneys to start talking jury.
I can't imagine less than 300, and 500 sounds outrageously high, but it's somewhere between those two.
Judge Deb Nelson eventually decided on a pool of 500, summoned over 3 days beginning on June 10th. 500 potential jurors? You really think that's going to be necessary to find 6?
Very potentially, because in the case of this magnitude of pretrial publicity, that's going to be the main issue, where people have heard so much about the case that they can't put it aside. And if that's true, then they can't be a juror.
Also discussed today, O'Mara's attempts to depose Trayvon Martin family attorney Benjamin Crump, who's hired an attorney of his own to block that.
We've done our case law research, and we'll wait for, get that to the judge and let her make a decision. But I don't believe that having an ESQ after your name makes you immune from deposition.
Now, the lawyers will return here to this courthouse 1 week from tomorrow to argue on whether Crump has to sit for deposition. The defense claims he has information that's relevant to Zimmerman and not protected by attorney-client privilege. Crump's attorney, though, says they put everything they know that is relevant into an affidavit, and the defense should be happy with that. Lauren?
Yeah, still all of this back and forth. You know, O'Mara said he wanted more time. The judge denied it. He would get more time if the immunity hearing was wrapped up in the trial. But how would that work exactly?
You know, the jury would not even know what's going on. The judge would be listening to all the evidence, and before it goes to the jury or at the end of the case, decide if the defense proved self-defense. Now, if so, Zimmerman goes free. The Martin family and estate cannot sue Zimmerman for wrongful death, and the state, the taxpayers, would have to pay Zimmerman's attorney's fees as well as lost income, for instance, that he received during this whole ordeal. If, though, the judge decides they didn't prove defense, self-defense, the jury could still decide that or acquit him based on the failure to prove beyond a reasonable doubt. So there's still many ways out for Mr. Zimmerman, even if he loses that hearing. But as you said, it gives the defense more time to get prepared if they do it during the trial.
Yeah, and we know that self-defense hearing is going to be like a mini trial anyway, Tony, and anything said then can be admissible during a trial if that happens. So makes sense.
So they'll do it at once.
All right.
Perhaps.
Thanks, Tony. Keep us posted. Let us know what happens.